of this.
Please knock that door. Come on from the chair.
Are we live?
You're live.
Can you see me?
Yeah.
What are the comments saying?
Check the YouTube.
Click those pages that I sent to you guys to see whether your
10 persons watching.
10 persons watching.
12.
Let's just wait a little. Let's just wait a little so more people will join this session.
There's a notification that his stuff is live on the channel.
I'm sure we have.
Keep it on.
Are we live?
Yes,
Yeah.
How many of us are online?
22 persons.
All of us in less than 2 minutes. I'm seeing.
So can you see me? If you're here, you're online already and you can see me, you can hear me, drop a message that you can hear me and you can see me. Drop a message wherever you're watching us from. Drop a message that you can see me and you can hear me. Wherever you're watching from, here in Port Harcourt, anywhere around the world, if you can hear me, if you can see me, let us know. Can you hear us?
Yes, we can hear.
Can you hear us? We need comments. Tell us where you're watching from. Wherever you're watching from, please tell us where you're watching from. Today, we will do justice to a few things that are very important to the scheme of work for the first semester contract law. That's what we are here to do. Can you hear me? Can you see me? If you can hear me, if you can see me, then drop a message. Let us know that the message is coming. Can they hear us? Absolutely. You can't hear me? What are the responses? If you cannot hear us, let us know.
Watching from River State University, Sarah Amar. Watching from Port Harcourt.
Can you hear me? Can you see me? Let us know. The last time we did live, we had technical issues. We're trying to be sure that the technical team is getting it right before we start. While we wait for others to join this live event, I want you to drop your name, where you're watching from, and whether you can hear us. afternoon and welcome to AruguInsights. We're about to begin. I'm Arugu Speaks on AruguInsights. We're delighted to have you join this live revision session designed specifically for law students and everyone that is interested in legal scholarship. Today, from now to 4 p.m., we'll be revising key legal principles and discussing practical approaches to understanding a bit difficult or gray areas of law. You know that here in AruguInsights, we are committed to making legal education accessible, analytical, and engaging. If you're joining us for the first time, kindly subscribe to the channel and invite your colleagues, friends, and family to be part of this history-making event here on AruguInsights. Let us begin our revision session. Can you hear me? If you cannot hear me, please let us know so that we can adjust the microphones and do what is necessary in the circumstance. AruguInsights, today we'll talk about a lot of things. We'll talk about a lot of things. Can you hear me? Can you hear me? If you cannot hear me, please drop a message. Let's do this as we wait for others to join us. Let's do this as we wait for others to join us. How many of us are online now?
24.
Okay, we can start. The other people can join us later on. From the beginning again. Good afternoon and welcome to AruguInsights and Arugu Speaks. Here on AruguInsights, we are delighted to have you join this live revision session designed specifically for law students and everyone interested in legal scholarship. Today, from now to about 4 p.m., we'll be looking at key legal principles and discussing practical approaches to understanding difficult areas of contract law, the gray areas we didn't really cover. Here, once again, we all know that AruguInsights is committed to making legal education accessible, analytical, and engaging. If you're joining us for the first time, kindly subscribe to the channel and invite your colleagues, your family members, your friends in other schools, UNIPORT, the Port Harcourt Polytechnic, University of Calabar, University of Nigeria, wherever your friends are, let them know. Lagos, Abuja, Kano, Kaduna, anywhere around the world, let them join us to have an idea of how the position of the law on contract law in Nigeria. Today, we will start with something that we least expect, and we'll be looking at electronic contracts, smart contracts, blockchain, and digital platforms. We will look at the evolution of digital transactions in Nigeria by way of introduction. Once again, I welcome everyone to today's session on digital transactions in Nigeria. The digital economy in Nigeria today, business transactions are increasingly conducted online, from your online shopping to cryptocurrency payments and automated digital agreements. Technology has fundamentally changed how contracts are created and enforced. The things we couldn't do 20 years ago, today we can do them with ease. Nigeria increasing internet penetration and policies like the National Digital Economy Policy and Strategy 2020 to 2030, digital technology is playing a major role in commerce, governance, and financial transactions. Today, the discussion will focus on 4 key areas. Before I go on, I want to thank the team that is working with us today. We are eternally grateful to all of you, Penua Jemima, King Itode Sokari, So Emmanuel, and then our technical head, Clever Chineye. I'm eternally grateful to all of you. Thank you for the good work you're doing here. AruguInsights. You know, when we do this, people don't know the amount of energy that is put behind this before the message goes out. So once again, to our technical team, Jenny, JD, Swo, Clever, thank you. Thank you. We are grateful to you for your expertise and your industry. Our discussion today will focus on 4 key areas: electronic contracts, smart contracts, blockchain technology, and digital platforms. By the end of the session, you will understand the legal framework regulating digital transactions in Nigeria and the challenges involved. Let us go to electronic contracts. What is an electronic contract? An electronic contract is simply a contract concluded through electronic means, such as your emails. On daily basis, you send emails, your website, go to www.this, your mobile applications, your online platforms, Jumia, this, Opay, that, and all of them. Examples include buying goods from Jumia, accepting terms on the website, online banking agreements. All of these form what we refer to as what? Electronic contract. What's the legal recognition for this in Nigeria? Electronic contracts are legally recognized under the Evidence Act, which allows electronic records and signatures to be used as evidence in court. Other supporting laws include the Cyber Crimes Prohibition, Prevention, etc. Act 2015, the Companies and Allied Matters Act, and then 2020, and then more recently, the National Digital Economy and E-Governance Act 2024 confirms that contracts can be formed through electronic communication. What are the key takeaways? Electronic contracts in Nigeria are valid as long as the traditional elements of the contract exist. What are the traditional elements? These are things we all know, but it's better to be superfluous here. We list them again: an offer, acceptance, consideration, intention to create legal relations, and all of that. Then you look at the capacity of the parties to contract and all of that. Those are electronic contracts. What are smart contracts? Smart contracts are self-executing agreements written in computer codes, usually operating on blockchain networks. An example: a smart contract may automatically release payment once goods are delivered. Legal status in Nigeria. Nigeria currently does not have a specific law regulating smart contracts, but they may still be enforceable under the general contract principles. Look at the admissibility of electronic evidence under the Evidence Act 2011, supports their possible enforcement. What are the advantages of smart contracts? Smart contracts offer automation of transactions, reduced transaction costs, transparency, faster execution. What are the challenges that come with them? Some legal concerns remain. There may be coding errors, liability for faulty code. In terms of dispute resolution, which court would have jurisdiction? Dispute resolution is the problem. And then in terms of enforcement, cross-border enforcement issues would arise. Look at blockchain technology. What is blockchain? Blockchain is a decentralized digital ledger used to record transactions securely. It is the technology behind cryptocurrencies, smart contracts, digital assets. Nigeria has adopted a policy framework through the National Blockchain Adoption Strategy. The importance of blockchain is that blockchain can help to improve transparency in government procurement, financial inclusion, secure record keeping, supply chain monitoring, and all of that. Again, for we all know that every coin has two sides. We've looked at the advantages of blockchain. What are the challenges that come with blockchain technology in Nigeria? Despite the high adoption rate, some problems remain. Poor infrastructure. We all know about poor infrastructure in Nigeria, electric power supply and all of that, power issues, regulatory uncertainty, and then limited institutional adoption. Now, let us look at what are digital platforms. Digital platforms are online intermediaries that connect users and services. Examples include social media platforms. Today, the social media is big business. Go to Facebook, TikTok, Instagram, all of them, big business. These are the examples of digital platforms. Today, almost every lady in Port Harcourt has an online shop. And so you have online marketplaces, and then you have fintech platforms. Regulation of digital platforms in Nigeria involves several laws and institutions. What are the key regulatory bodies that are in charge of this very important aspect of our daily existence? You have the National Information Technology Development Agency, NITDA. You have the Federal Competition and Consumer Protection Commission. What are the relevant laws? You have the Nigeria Data Protection Act 2023, and then you have the Federal Competition and Consumer Protection Act 2018. All of these laws aim to ensure consumer protection, data privacy, fair competition in the digital marketplace. In all that we've talked about, electronic contract, digital platforms, blockchain technology, and all of them, what are the key challenges that we have in Nigeria? We have made good progress, but there's so much we need to still do to ensure our supply. And then digital literacy gaps. You know, even in the university today, students can watch movies online, but if you tell them to hold an online class, they have a difficulty. They tell you no. You give them a material online, they say they need to print it out. What is the need for and digital platform Data Protection Act 2023, further reforms are necessary to provide clearer regulation for emerging technologies. With stronger legal if you cannot hear us, then thank you. electronic contracts, smart contracts, blockchain technology, and digital platforms are reshaping how agreements are created and enforced. Although Nigeria has established a legal foundation through statutes like the Evidence Act 2011 and the Nigeria Data Protection Act 2023, further reforms are necessary to provide clearer regulation for emerging technologies. With stronger legal frameworks, improved infrastructure, and enhanced digital literacy, Nigeria is well positioned to become a leading economy in Africa. Once again, I want to thank you for joining us. If you're finding our discussion helpful, please like the video, subscribe to the channel, share with other law students and other professionals and those who are interested in this. You can also drop your questions in the comment section, and our team is here to answer all your questions. Now, we will consider a likely examination question. Likely examination question. Get ready. Get ready. Let us look at this question. Digital technologies have significantly transformed commercial transactions in Nigeria, particularly through the emergence of electronic contracts, smart contracts, blockchain technology, and digital platforms. With reference to the relevant legal framework in Nigeria, examine the role of electronic contracts, smart contracts, and blockchain technology in modern commercial transactions. In your answer, discuss the legal recognition of petroleum contracts, the potential enforceability of smart contracts, and the regulatory implications of blockchain technology within Nigeria's digital economy. You know that for the purpose of examination, the core law questions are 7, continuous assessment is 30 marks, the exam is 70 marks. They will set 6 questions for you to answer any 4. In Nigerian law exams, there are no compulsory law questions, so out of the 4, out of the 6, you have to answer any 4 questions that you like. Okay? Now, that is it. Go ahead. Let's go ahead and consider the answer to the question. I have always told my students that for every examination question, you must start with a general introduction or an overview. And for a question of this nature, I will start with something like this. The rapid development of digital technology has significantly transformed the nature of commercial transactions worldwide. In Nigeria, the increasing use of online platforms, electronic communication, and digital financial systems have facilitated the emergence of new forms of contractual relationships. These include electronic contracts, smart contracts, blockchain-based transactions, and all of them. The Nigerian legal system has gradually adapted to these developments through institutional reforms and regulatory policies aimed at recognizing electronic transactions and ensuring the enforceability. These developments have become central to the growth of Nigeria's digital economy. If I were to be marking your script, or from my own marking scheme, you're almost close to passing your exams. It shows that you know what you're doing, you have an idea of what you want to do, You are intentional about what you want to do. You are not groping for a touch. You are at home with the position of what is going on in Nigeria. And for me, that changes my mind positively towards what you're doing. That changes my mind towards what you're doing. If you can hear us, this is very important. We are answering questions. If you can hear us, let us know. If you cannot, drop a message so that we can correct what we are.
Continue.
Electronic contracts refer to agreements formed or executed. Sorry, we are having some technical issues here. Can you hear us? Can you hear us? Sorry, technical issues here and there. Electronic contracts, once again, now I'm answering the question. After the introduction, I want to define what is electronic contracts, and they refer to agreements formed or executed to electronic means such as emails, websites, mobile applications, or digital platforms. Unlike traditional contracts that require physical documentation and signatures, electronic contracts are concluded through digital communications. In Nigeria, electronic contracts are recognized under the Evidence Act 2011. The Evidence Act permits the admissibility of computer-generated evidence and electronic records in legal proceedings. It also recognizes electronic signatures where they can identify the signatory and indicate approval of the transaction. Additional statutory support is provided by the Cyber Crimes Prohibition and Prevention Act of 2015, which protects electronic communications and criminalizes online fraud and cyber-related offenses. Furthermore, the Companies and Allied Matters Act 2020 allows electronic filings and digital documentation in corporate transactions. More recently, the National Digital Economy and E-Governance Act 2024 explicitly recognizes the validity of contractual offers and acceptances that are made through electronic communications. This confirms that contracts cannot be declared invalid solely because they were concluded electronically. I want you to take note of that. Nevertheless, electronic contracts must still satisfy the traditional elements of a contract formation under Nigerian contract law, namely offer, acceptance, consideration, and intention to create legal relations. Let us look at smart contracts. There, if you do this, we just know that you're moving towards an aim. If you do this, you're moving towards an aim. If you do this, you're moving towards an aim. What are smart contracts? Smart contracts represent a technological advancement in digital contracting. The automated agreements embedded in computer codes and executed on blockchain networks once predetermined conditions are satisfied. For example, A smart contract will automatically release payment to a supplier once goods are delivered and verified within a digital system. Although Nigerian law does not yet contain specific legislation governing smart contracts, they may still be enforceable under general contract principles, provided that the essential elements of a valid contract are present. We have said this, we are repeating this, you need to take note of this. The evidentiary recognition of electronic records under the Evidence Act 2011 further supports the admissibility of smart contracts in judicial proceedings. However, several legal challenges remain, including the allocation of liability for coding errors, the identification of contracting parties in a decentralized system, and the determination of jurisdiction in cross-border digital transactions. That is formats gone again, if I were to mark, when you do that. Blockchain technology. Blockchain technology is a decentralized digital ledger that records transactions in a secure, transparent, and immutable manner. It forms the technological foundation for cryptocurrencies, smart contracts, and other digital financial world systems. Nigeria has adopted a policy-oriented approach to blockchain development through the National Blockchain Adoption Strategy that promotes the integration of blockchain technology into sectors such as financial services, supply chain management, and government procurement. Regulatory oversight of blockchain-based financial instruments is also exercised by the Securities and Exchange Commission of Nigeria under digital asset regulations issued pursuant to the Investment and Securities Act. Blockchain technology offers numerous advantages, including enhanced transparency, reduced transaction costs, and improved security of digital records. However, challenges such as regulatory uncertainty, infrastructural limitations, and cybersecurity risk continue to affect its implementation in Nigeria. We talk about Yahoo boys and all of that. There are a lot of risks. You think you're contracting with so and so person. You don't know that there is somebody who is impersonating the person and claiming that he or she is the person, and you make payment only to discover that you're paying the money to a wrong person. Then, by way of concluding from what we have done already, if you do this, just know that you have an A already. Concluding, electronic contracts, smart contracts, blockchain technology represent significant developments in modern commercial transactions. Nigerian law has begun to accommodate these innovations through statutory provisions recognizing electronic records and digital transactions. However, the absence of specific legislation regulating smart contracts and blockchain-based transactions indicates the need for further legal reforms, strengthening Nigeria's regulatory framework will enhance legal certainty and promote the continued growth of Nigeria's digital economy. Can you hear us? Can you hear me? I just want you to know that if I am to write contract law, I would answer the question on electronic contracts because it's very easy, very straightforward, very direct. There is no way they can twist this question that you don't know how to answer. It is easy, it is direct, Very straightforward. Look at this to help you. Listen to the video again. It will help you. I have brought another question again on blockchain contracts. Sorry, please. Again, let us know one thing, that the emergence of blockchain technology and digital platforms has significantly transformed the manner in which contracts are negotiated, concluded, and performed. Smart contracts executed on blockchain enable automated performance of contractual obligations without the need for traditional intermediaries. Particularly, digital platforms facilitate electronic agreements between parties who may never meet physically. You go into multi-million naira businesses with people you have not met with. You buy things from Jumia, from Amazon. You don't know who is selling, you don't know who is buying, you don't know who is packaging your what you have paid for. It gets to you and you go home celebrating. Wonderful technology, beautiful world. The world is becoming a global village and all of that. With particular reference to the principles of Nigerian contract law, discuss the legal implications of blockchain technology in digital platforms in the formation and enforcement of contracts. Here, again, a different blend of the first question. In your answer, address the following issues. What are the traditional elements of a valid contract in Nigeria under Nigerian law, and how do they apply to blockchain-based transactions? We all know that. B, what is the concept of smart contracts and whether they satisfy the requirements of offer, acceptance, consideration, and intention to create legal relations? C, what is the legal recognition of electronic contracts under Nigerian law? D, what are the challenges that are associated with enforcement, jurisdiction, and dispute resolution in blockchain-based contractual agreements? E, the prospects of blockchain technology for the future of commercial contracting in Nigeria. Again, I have said this and I'll repeat again, all law questions carry 17 and a half marks. To give you the 4 of them, you answer to give you 70 marks. Listen, you need to look for your area of strength and answer 4 out of the 6 questions that will come. There is no compulsory law question in our universities. I don't know of other universities, but I know that here in the Rivers State University, no law question is compulsory. The lecturer or the examiner is at liberty. The examiner has at liberty to say 6. Can you hear me? Can you hear me? Yes. So now, meaning of blockchain, smart contracts, and digital platform. Introduction. 2 marks. Generally, the introduction, just explanation of blockchain technology as a decentralized digital ledger that records transactions securely and immutably. Explanation of smart contracts as self-executing agreements where the terms of the contracts are written in code and automatically enforced when conditions are met. Digital platforms like e-commerce and online transaction systems that facilitate contractual relationships electronics. You must make sure that you give reference to the Evidence Act 2011 recognizing electronic evidence, give the reference to the Cyber Crimes Prohibition Prevention Act 2015, and then that is your introduction. Perhaps your introduction will carry 2 marks, and if I'm the one marking your paper and you've done all of that, I will leave no stone behind, I'll give you the 2 marks. Elements of a valid contract under Nigerian law. What are the elements of a valid contract? This is elementary. Every law student should know that for there to be a contract, there must be an offer, there must be an acceptance, the traditional elements of a valid contract, and relate them to digital transactions. That's all you would do. A valid offer must be clearly communicated and accepted. Electronic communications can constitute valid acceptance. That's correct. What is the relevant case? Look at the case of Khalil and Carbonic Smoke Bomb Company. Each case talking about issue of acceptance of unilateral offer. And then what is consideration? Something of value, exchange between parties. What is the relevant case? Look at the case of Corey and Meister. You can't, when you talk about consideration, if you don't drop Corey and Meister, then you have not started. When you talk about consideration, if you don't drop Corey and Meister, then you have not started. Gentlemen, the elements of the traditional elements of a contract, offer, acceptance, consideration, intention to create legal relations, and then you look at the capacity of the contracting parties. So, when we talk about electronic contracts, have they met this threshold? Who made the offer in the electronic contract? Who is the acceptance? What is the consideration that is furnished? Consideration as defined by the English court in Corey and Meister. So, and then the intention of the parties to be legally binding. We all know that in Nigeria, generally in commercial transactions, the intention of the parties to be legally binding is presumed in commercial transactions. The intention of the parties to be legally binding is presumed in commercial transactions. In domestic and social contracts, that presumption is not there except the parties show the intention that they intend to be legally binding. And you also know that in between the two extremes, commercial transaction where there's a presumption that they be legally binding, and social and domestic contracts where there's a presumption that they not be legally binding. In between the two is an intermediate position where the court will need to look at the facts of the case to determine whether or not the parties intended the contract to be legally binding. Gentlemen, If you can hear me, drop a message, let us know. If you cannot hear me, please do drop a message so that our technical team can do the needful. Can you hear me? No. The withdrawal of British troops. Can you hear me? Whenever you are faced with a question, just make sure that you calm down, look at the question again, read the question over again, know what you're doing, and then apply the necessary principles of the law, and it will help. Sorry, it's like we're having more issues here.
Go on break.
We'll be taking 1 or 2 minutes of break so that our team can get back to what, sorry, we're having issues here. Can you hear me? Please hold on a little. Our team is having some technical issues. Our team is having some technical issues. Our team is having some issues. Let us wait. While we are waiting for them, ladies and gentlemen, I want to use this opportunity to thank every one of us that is online today. Every day we are trying to make sure that we get this thing right. Rome was not built in a day. We're trying to make sure that we get this thing right. A team is working around the corner to get this right. And I hope and I pray that they get this right. But before they get this right, I just want us to know that according to Professor Isisage, a contract is an agreement between two parties that a court of law will enforce. And for there to be a contract, there are You look at the capacity of the parties to contract. Can you contract with a madman? Can you contract with a child? What are the circumstances under which you can contract with a child? And all of that. But today, with the advancement of technology, we have come to the realization that we wait for a team to get us back on track. I just want us to know that with technology, some of the things that hitherto we thought we couldn't do, we're doing them today. Technology is bridging that gap and all of that. Technology is bridging that gap. I'll invite my colleague, my friend here in AruguInsights to please come and deliver a brief expose on consideration as an element of contract, looking at the classical definition of consideration by the English court in Meister and Corey, Manuel, please come and look at constitution. Manuel,
It has worked, sir. Yes. Is that where we are?
we were, yes. So we are talking about the second question. The second question, Bob? Yes, yes. We have talked about, sorry, we're back, we're sorry for that break. We are talking about the rapid development of digital technology that has, significantly transformed the nature of commercial transactions worldwide in Nigeria. And then the increasing use of online platforms, electronic communications, and digital financial systems facilitated the emergence of new forms of contractual relationships. And we have said that these are smart contracts, electronic contracts, and blockchain-based transactions. Our legal system has gradually adapted to these developments through statutory reforms and regulatory policies aimed at recognizing electronic transactions and ensuring their enforceability. These developments have become emails,
From the electronic contract. Go on, sir.
using emails, websites, mobile applications, or digital platforms. Unlike the traditional contracts that require physical, unlike the traditional that require physical, thank you. Go down, go down. Unlike the tradition, un- unlike the traditional contract that require physical documentation and signatures, electronic contracts are concluded through digital communications. We have the Evidence Act that's recognized electronic contracts. They are admissible in the court of law. Computer-generated evidence is admissible, and electronic records in legal proceedings. It also recognizes electronic signatures where they can identify the signatory and indicate approval of the transaction. Additional statutory support is provided for by the Cybercrimes Prohibition Prevention Act 2015 that protects electronic communications and criminalizes online fraud and cyber-related offenses. Furthermore, the Companies and Allied Matters Act 2020 allows electronic filings and digital documentation in corporate transactions. More recently, the National Digital Economy You know, this confirms that contracts cannot be declared invalid solely because they were concluded electronically. Nevertheless, electronic contracts must still satisfy the traditional elements of contract formation under Nigerian law: offer, acceptance, consideration, and intention to create legal relations. And then let's look at smart contracts again. Just define it, already defined before in our first question that we answered. A smart contract represents a technological advancement in digital contracting. The automated agreements embedded in computer code and executed on blockchain networks once predetermined conditions are satisfied. For example, a smart contract may automatically release payment to a supplier once goods are delivered and verified within a digital system. Although Nigerian law does not contain specific legislation governing smart contracts, they may still be enforceable under general contract principles, provided that the essential elements of a valid contract are present. The evidentiary recognition of electronic records under the Evidence Act 2011 further supports the admissibility of smart contracts in judicial world proceedings. Always, we say this. However, several legal challenges remain, like the location of liability for coding errors, the identification of contracting parties in decentralized systems, and the determination of jurisdiction in cross-border digital transactions. What again are blockchain technology? Define them. When you get a question, look at them and define them as they come. Blockchain technology is a decentralized digital ledger that records transactions in a secure, transparent, and immutable manner. It forms the technological foundation for cryptocurrencies, smart contracts, and other digital financial world systems. Nigeria has adopted a policy-oriented approach to blockchain development through the National Blockchain Adoption Strategy that promotes the integration of blockchain technology into sectors as financial services, supply chain management, and government procurement. Regulatory oversight of blockchain-based financial instruments is also exercised by the Securities and Exchange Commission under the digital asset regulations issued pursuant to the ISA, that is the Investments and Securities Act. Blockchain technology offers numerous advantages, including enhanced transparency, reduced transaction costs, and improved security for digital records. Again, there are challenges such as regulatory uncertainty, infrastructural limitations, cybersecurity risks, and they continue to affect the implementation in Nigeria. Concluding, electronic contracts by their nature, smart contracts by their nature, and blockchain technology, they all represent significant developments in modern commercial transactions. Nigerian law is beginning to improve to accommodate these innovations through statutory provisions recognizing electronic records and digital transactions. However, the absence of is a problem. Strengthening the regulatory and legal framework will enhance legal certainty and promote the continual growth of our digital economy. Question number two. Question number two. Blockchain technology, we all know, and digital platforms, commercial platforms, have significantly transformed the manner in which contracts are negotiated, concluded, and performed in modern commerce. Smart contracts executed on these blockchain contracts enable automated performance of the contractual obligations without the need for additional intermediaries. Again, digital platforms they facilitate electronic agreements between parties who may never physically meet. With reference to all of these principles, look at whether contract law in Nigeria, discuss the legal implications of blockchain technology and digital platforms in the formation of enforcement of contracts. I want you to know that in your answer, you must address the following issues. You must address the traditional elements of a valid contract under Nigerian law and how they apply to blockchain-based transactions. You must address the concept of smart contracts and whether they satisfy the requirements of offer, acceptance, consideration, and intention to create legal relations. You must look at the legal recognition of electronic contracts under Nigerian law. You must look at the challenges associated with enforcement, jurisdiction, and dispute resolution in blockchain-based contractual arrangements. The prospect of blockchain technology for the future of commercial contracting in Nigeria. You must also look at that. Are we going to go back to Egypt, or we are going to go back to the promised land? Are we going to go back to the era of paper and pen, or we are going to join the era of modern technology? Again, explanation of blockchain technology as a decentralized digital ledger that records transactions securely and immutably. You have to do that. You must explain what smart contracts are. They are self-executing agreements where the terms of the contracts are written in code and automatically enforced when conditions are met. 3, you must make an explanation of digital platforms. Example, the e-commerce and online transaction systems that facilitate contractual relationships both electronically. You must make reference to the Evidence Act to support your position. You must make reference to the Cybercrimes Prohibition Prevention Act 2015 to support your position. What are the valid elements of contract under Nigerian law? Students should be able to discuss the traditional elements of a valid contract and relate them to digital transactions. Offer and acceptance. An offer must be clearly communicated and accepted. Electronic communications can constitute valid acceptance. What is the relevant case for that? Khalil and Kabbalah smoke ball. That's the case talking about acceptance of unilateral offer. And then you must talk about consideration, something of value exchange between parties. What is the authority for that? Courier and Meister. Then you talk about intention to create legal relations. Parties must intend their legal consequences. And then what is the authority for that? Balfour and Balfour. And then you must talk about capacity and legality. Parties must have the legal capacity and the subject matter must be lawful. Hey, whenever you talk about the elements of contract under Nigerian law, the Supreme Court decision in Orient Bank Nigeria PLC and Bilante International Limited is just when the moment you talk offer, just drop Orient Bank. Capacity, just drop Orient Bank. Acceptance, just drop Orient Bank. If you cannot remember any case, there is one case you must not fail to remember, and that is the decision of the Nigerian Supreme Court on the elements of a valid contract in Orient Bank Nigeria PLC and Bilante International Limited. Hey, this one is academic fraud. I'm just telling you a shortcut to success. The moment you are talking about the elements of offer, of contract, traditional elements of contract in Nigeria, you should not fail to support your position with Orient Bank Nigeria PLC and Bilante International Limited. Then, application of contractual principles to contracts. The students should be able to explain how smart contracts satisfy requirements of contract formation. What is the key points you need to state? Offer and acceptance may occur through digital protocols or automated code. That's why when you want to sign and I agree to the agreement, you click the box. Consideration may occur through cryptocurrency or digital assets. Blockchain ensures immutability and transparency of contractual terms. What the legal relevance? Recognition of electronic transactions under Nigerian law. What is the relevant law? Again, Evidence Act sections 84 and 93 on electronic evidence, cyber crimes, prohibition, prevention, Act 2015, enforcement and jurisdictional challenges. The student should identify legal difficulties arising from blockchain contracts. One, jurisdiction. Blockchain networks operate across multiple jurisdictions. Identity of parties, anonymity may complicate enforcement, dispute resolution, difficulty reversing automated transactions, and then choice of law problems in cross-border digital contracts. What is the relevant case? Look at the case of Adesanya and Otuewu on locus standi and enforceability. What is the institutional framework? You look at the Central Bank of Nigeria, regulation of digital financial transactions. You look at the National Information Technology Development Agency, digital economy regulation. You look at the Securities and Exchange Commission through their regulation of digital assets and investment platforms. How do you conclude to get the maximum marks? Students should conclude that blockchain and digital platforms do not eliminate traditional contract principles, but rather adapt them to technological environments. Nigerian law already accommodates electronic transactions through legislation and judicial interpretation. Future reforms may include specific legislation recognizing smart contracts and blockchain-based agreements. Reference may be made to the initiatives of the Federal Ministry of Communications, Innovation, and Digital Economy. I want to thank you. Sorry for the technical issues that we have experienced. I'm glad that some of you are still with us. We want to thank you for your faithfulness. With time, we're going to get all of this better when we have everything that we need here. The internet issue here is a problem, but we'll get that correct. We have options available to us, but in all, I want to appreciate all who are still with us. Now, let us go to a banker. This is coming. You know, quite lately, Nigeria, we were treated to the story of Pastor Okonkwo and then the lady who is the Nollywood celebrity, Doris Ogala, over the breach of promise to marry. And the question that keep coming is whether the lady had the case. This is a problem question. There is one Mr. David Okafor, a prominent businessman in Port Harcourt, who is alleged to have breached a promise to marry one Mr. Daisy Nwosu, a public figure and social media personality in Nigeria. Their romantic relationship began in 2018 and lasted several years. During that period, Mr. Okafor allegedly introduced Daisy to members of his family, invited her to family gatherings, and exchanged several messages affirming his intention to marry her. Daisy claims that she relied on these assurances by incurring substantial expenses in preparation for the anticipated marriage and by making personal and financial commitments in expectation of the word union. The relationship eventually deteriorated when Mr. Okafor publicly married another woman. Daisy has therefore instituted an action claiming 5 billion as damages for emotional distress, reputational damage, and financial losses resulting from the alleged breach of promise to marry. We reference to Nigerian law, explain the principles governing the presumption against legal intention in domestic or social agreement such as romantic relationships or engagements. Outline the exceptions to this presumption, citing relevant authorities. Apply these principles to Adese's claim and determine whether a breach of promise to marry may give rise to enforceable contractual or tortious liability under Nigerian law. One, when we talked about the intention to create legal relations, there's a presumption against legal intention in domestic and social agreements. That one we know already. And the foundational requirement for a valid contract under Nigerian law is the intention of the parties to create legal relations in agreements arising from domestic, social, or romantic relationships. The law presumes that the parties do not intend the arrangements to be legally binding. Such arrangements are generally regarded as moral or social undertakings rather than enforceable contracts. And the classical authority for this position of the law establishing this principle is the English case of Balfour and Balfour. In that case, the court held that the agreement between spouses in a domestic setting lack contractual intention and are therefore unenforceable. Nigerian courts follow this common law principle as part of the received English law governing contracts. Gentlemen, I want you, ladies and gentlemen, I want you to take note of this. Promises arising from romantic relationships and engagement, including promises to marry, may initially rule established in Balfour and Balfour, the presumption against legal intention is reportable where the surrounding circumstances demonstrate that the parties intended legal consequences. When one, agreements are made in contemplation of legal consequences, where the parties clearly intended the arrangement to have legal effect, the presumption may be displaced. That's the case of merit and merit. The court enforced a written agreement between separated spouses where it was clearly intended to be legally binding. Two, another case where the presumption will be rebutted is where there is reliance or detriment. I relied on what you promised me. I suffered a detriment. I incurred losses. The law cannot allow you go free. In that case, if one party acts to their financial detriment in reliance on a promise, courts may infer legal intention. Look at the case of Parker and Clark. A promise concerning accommodation became enforceable because the promisee relied on it by selling everything that he owned at a cheap price, relocating from one city to another. The court said the man having altered his position and suffered a detriment. The man who promised him the house cannot send him out and then rely on the defense that it was a social or domestic contract not intended to be legally binding. Another exception to that rule is when there is this Nigerian position on promise to marry. Nigerian courts have recognized that a promise to marry can give rise to legal consequences where the promise is clearly established and subsequently breached. This position was affirmed by the Supreme Court in the case of Eze and Anata. We've discussed about this case. If you answer the question and there is no Eze and Anata, just know that you are not doing the right thing. As far as the issue about breach of promise to marry in Nigeria is concerned, the Baba of them all, the authority for that proposition of the law is Asiana Anata. In that case, the Supreme Court held right. We know where the issue is coming from. Ladies and gentlemen, we assure you that we'll correct it next time. We are going to correct our next life. We will correct it. We will get it right. In Ezra and Anatan, the court held that an action for breach of promise to marry is maintainable under Nigerian law where a definite promise to marry is established. Then you're just wasting your time. Ezra and Anatan. The court interfering with our network here. The court held that a breach of promise to marry is maintainable under Nigerian law where a definite promise to marry is established and unjustifiably broken. Remember, ladies and gentlemen, as far as you want to answer this question, the law in Nigeria, the case law in Nigeria is the decision of the Supreme Court in Eze and Anata. Then three, let us apply these principles. We have moved from Balfour and Balfour to Clark and Parker. Now we've got to Eze and Anata. How do we apply these principles of law? How do we apply these principles of law to the facts of the case? One, existence of a promise. For existence of a promise, Adeze must prove that Mr. Kafo made a definite promise to marry her. Evidence such as messages, conduct, and introduction to family members may support this claim. In Eze and Anata, the Supreme Court emphasized that a valid promise to marry must be clearly proved, and mere friendship or romantic relationship is insufficient. Breach of promise to marry. A breach occurs where the promisor refuses or fails to marry the promisee without lawful justification. That is settled, that is simple law. Breach of promise to marry. A breach occurs where the promisor refuses or fails to marry the promisor without any lawful justification. Mr. Calford's marriage to another woman may constitute evidence of repudiation of the promise if the promise is proven. Requirement of consideration. The courts have held that mutual promises to marry constitute sufficient consideration in law. Thus, if both parties agree to marry each other, a contractual obligation may arise. Damages. Where breach is established, damages may be awarded for loss of reputation, humiliation, or emotional injury, financial expenses incurred in preparation for marriage. However, in this case, the amount awarded must be reasonable and not speculative. A claim of 5 billion may be considered excessive and less on excessive. The Nigerian Supreme Court in Asia and Anata, the court will determine whether a definite promise to marry existed, whether the promise was unjustifiably broken, whether the claimant suffered provable worth damages. If these elements are established, a daisy may succeed in an action for breach of promise to marry, though the damages awarded will likely be far less than the 5 billion claim. Then, by way of concluding, let us all know that under Nigerian law, those domestic agreements are generally presumed not to create legal relations. A promise to marry constitutes an important exception where the promise is clearly established and subsequently breached. The Supreme Court decision in Asia and Anata confirms that such claims are legally recognizable, provided the claimant proves the existence of the promise, its breach, and resulting what? Damage. I want to thank you. We appreciate you. You have any question you can ask? I have more questions already here solved, but because of time, we will not have time to take more of them. Thank you for joining us. Drop your questions. We will answer them as soon as we can. Appreciate it. For those of you that have not subscribed, please